Greetings. Welcome back. This is chapter 14. I'm going to make this one up for you. Chapter 13 was really long. It was 25 minutes long, so I'm really going to keep this one short. Mainly because uh, not a lot of this is going to apply to you in your professions unless you plan to go federal. And not to say that none of you are going to go federal, but I tend to believe because of most of the people that I've been surrounded by in my academic career and my professional career, most people go the state route. So very rarely are you going to see any of these concepts. But what we're really going to try to talk about here today is some very unique things, which is this idea of the misplaced reliance doctrine in chapter 14. So this is a really good setup to everything about the federal government's ability to wiretap. Specifically, the misplaced reliance doctrine says this: be careful what you say to other people because they may be wearing a wire. That's pretty much what the whole doctrine is all about. This idea that who you place your trust in, oh, excuse me, excuse me again, I apologize. Uh, so back to what I was saying. The misplaced the people that you speak to, you need to be careful on who you are talking to because you never know when they're going to be wearing a wire. You never know when they're going to tell the information that you've told them to someone else. I mean, you are really running the risk of who you tell your information to. So, as a lawyer to a bunch of students who are trying to understand this information, I will say always keep incriminating information to yourself. Keep that to yourself. Do not ever plan on telling anybody that information because it could always come back to be used against you. It could be used to have a warrant issued for your arrest. It could be used to have a warrant issued to search you. It could be used against you to have a warrant issued to wiretap you. It just goes on and on and on. So that's the misplaced reliance doctrine. It's on you. It's your risk. Now, this idea of the misplaced reliance doctrine has created, sort of a hole. It leaves a lot open for the federal government to go around in there and do stuff. And you'll see throughout the chapter this ever evolving landscape that the Supreme Court has developed on the idea of using technology to hear what or find something that a person has or has said. And that's a bit of a problem. And it starts, and I think I referenced this before in an earlier video. At Katz versus United States, this is the phone booth case. This was the first case that I read in my criminal procedure course in law school. And my professor, I remember him standing there specifically saying, he said, look, if you're out in the open, they can take whatever they want. But in Katz, it was different because there was the phone booth. And the police officers had to use something to listen in. And not only did they have to use something, they had to use something that wasn't readily available to the public. They had to use a listening device. And in the 1960s or 70s, I think it was the 60s, I think it was 1964 actually. In 1964, when Katz came out, listening devices, you couldn't get those readily. You couldn't walk into Walmart and get them. Today, you could probably get them pretty easily. So the idea of putting a listening device on a phone booth today probably would not create a reasonable expectation of privacy. But now there's other issues, like there's the Jones case that shows up later on in your chapter. The police, the federal government in that situation, they installed a tracking device that tracked the suspect for 28 days. 28 days. And the court said that that was a search. And it wasn't because it went to the suspect's house. That was one of the reasons the court said. But the court mainly said it was such an invasion. It was such a physical intrusion. So it wasn't so much about the actual information that was being gathered. It was the fact that the government installed itself, essentially, on this person's car for 28 days. And that was a physical trespass to the United States Supreme Court. So you see where these balances are coming from. Like the Supreme Court is trying to keep it in check because there's this misplaced reliance doctrine that leaves this just giant open fields of just anything the federal government can do, and the federal government's come through and issued all these statutes, and they're like, yes, we can do this, and we can do that, we can do this, because, at the end of the day, it falls on the misplaced reliance doctrine. It's up to the person to kind of filter themselves essentially, and that can be hard. It's kind of like, hey, federal government, you're only so big, you can't get any bigger, and that's what the Supreme Court's been trying to do, is kind of keep them in check, because if they were to let them really run wild with that, then wiretapping would just go crazy. It's already big. You've heard about it already, especially with relation to the U.S. Patriot Act and so on and so forth. This idea that technology is really catching up with us. If you look at some of the statistics here on page 418, you can see wiretaps accounted for 96% of the warrants that were issued in the United States. Of those 96%, 98%. So 98% of the 96% were for cell phones and other portable devices. We have cell phones. This isn't big time corporate America type stuff that they're trying to issue these electronic wire warrants for. These are you and me type of warrants. So take that in consideration when you think about this. And 85% of the warrants were cases involving drug offenses. So we talk about, in some of your other cases, you talk about, criminology and this idea of, should we criminalize drug offenses or anything? But at the end of the day, we criminalize drug offenses. That is a cold, hard fact. Whether we agree with it or not, that's a cold, hard fact. And we also recognize how much drug offenses actually, take up of the entire criminal world in the United States, up to, all the people that we have in jail and in prisons for it. So think about that as well. And this is just this whole area, this whole body law. It scares the crap out of me just being an attorney, because it really all falls back on that, what we entered into with the misplaced reliance doctrine. And then there's even these situations where, it doesn't even apply. The Fourth Amendment doesn't even apply. If you look on page 420 here, you talk about pen registers and trap and trace devices. Now, Congress has kind of come through sometimes with respect to these and kind of stopped itself. Look, we understand, that we have a right to do this, but just because we have a right doesn't mean we should, because it takes away from the people that, put us in these seats, the American public. But if you don't know what a pen register is, it's this idea that the phone company actually is able to track. So your cell phone company is able to track the numbers you punch into your phone. Now, if you're like, well, I always have contact. Let's just press the contact, and then boom, that's whatever. Well, that contact, that's a saved shortcut, but the shortcut always registers the number into what it's being called to. So if you were to pull up if I were to subpoena the phone register, it wouldn't show up, called Janie. It would show up, 304, whatever. It wouldn't show up as your contact. So even just pressing the contact, it still registers that whole number. And that number itself is actually not protected by the Fourth Amendment because it's placed with a third party. So there's no reasonable expectation. Same thing with the trap and trace devices, tracks where the phone calls are being incoming, outgoing. Bumper beepers, those are tracking devices, but I'm not going to go too much about them because there's that Jones case that talked about 28 days on a car. Not really worried about that. And like I said, the last thing I want to touch on real quick is the Foreign Intelligence Surveillance Act. And the reason why I want to do that is because I want you to understand just how special these things are, especially when it comes to the idea of electronic items. So even though the federal government is put in check by the United States Supreme Court on how they're able to use technology and getting search warrants or doing things without a warrant, tracking people with a surveillance device that's not available to the public, they need a warrant to do that. But the federal government the Supreme Court has always recognized a very special exception, and that is for national security interests. And this Foreign Intelligence Surveillance Act creates this Foreign Intelligence Court. And the members of the court are appointed by the U.S. Supreme Court Chief Justice Roberts. They are appointed to this court, and they have their own special little body. And this is supposed to be just like a, go straight to go, collect your $200, right? That's, when you play Monopoly, you always got to go around the board, right? That's the general rule. You always have to go all the way around the board. But every once in a while, you get the card that says, go across go, or go somewhere that crosses go and collect your $200, right? You go straight to the front of the line. Well, that's what this Foreign Intelligence Court does. It's the way the executive branch can go directly to go and collect its $200 if there's a national security interest involved. And it has to be foreign, and there's a lot of other things, but just understand that. So if you are a state official or you're a state officer or something in that capacity, and you're investigating something fairly heavy duty stuff, and that's the only reason why you would ever be in this material here in your professional career, is if you're in some heavy duty stuff. Know that you have options. You should always reach out to your federal counterparts. That's the first thing I would tell you, is that working and corroborating and collaborating with your federal brothers and sisters in whatever state agency you work in, or likewise, if you're a federal agency, you have these things right at your disposal. You still include the state agencies so that they know what's going on. Work together and know that these things, like if there's a national security interest involved, you have this available to you that allows you to jump straight to go to get that warrant that much quicker, so that you can protect and serve the public that much easier. That's chapter 14. I told you I promised to make it up to you for the chapter 13 lecture that went on a little bit longer than I wanted to. If you have any questions, if you want to discuss more in detail about this, just email me, and I'll be more than happy to get into a deeper, more scholarlistic conversation with you about it. If not, I'll see you for chapter 15.